there is no mentioning of minorities' rights, and minorities' rights play a predominant role after the World War I and World War II. Though no attempts were made during the Declaration of Universal Declaration of Human Rights way back in 1948, steps were being taken at that point of time, which culminated ultimately in 1992, that international community felt that you need to have a special declaration on rights of persons who are ethnically minorities, religiously minorities, or it could be a linguistic minority. And this all culminated into a declaration of 1992, which was signed on 18th December 1992. And therefore, we as Indians and we as a member of international community celebrate this particular day as International Minorities Day. And this celebration is all throughout the world. However, as far as Indian jurisprudence is concerned, it was not necessary that the General Assembly should declare about the minorities' rights and then that the India should implement such particular legal regime in the Indian jurisprudence. In fact, the Constitution of India, which came into force in 1950, profusely speak about the rights of linguistic minorities and the rights of religious minorities. However, it could be a coincidence that in 1992, General Assembly of United Nations declared these rights of minorities, and in the same year, the government of India also, just a second, the government of India also brought a special legislation, the National Commission for Minorities Act 1992. In fact, if you look at the dates of commencement, this act has come into force on 17th May of 1992, whereas the international declaration which we spoke about has come into existence in the month of December 1992. So, time-wise speaking, India is pre-scheduled as far as introduction of a law relating to minorities is concerned. In India, as I said, we have spoken profusely about the rights of minorities in the Indian Constitution. Indian Constitution has in fact declared and recognized the rights of religious minorities and the rights of linguistic minorities as well. However, the terms of international conventions on declaration of this particular rights are broad enough to include even ethnic minorities, religious minorities, and linguistic minorities as well. Coming to the Indian jurisprudence, as I said, since the Indian Constitution speaks in detail about the minority rights and which was supplemented by this particular National Commission for Minorities Act, a separate ministry has been established under the government of India, what is known as Ministry of Minorities Affairs, which takes care of minority rights at the national level. And as far as states are concerned, even states also have established minority commissions, minority departments at their own level so that minority rights are taken care of. Now the question comes, who are the minorities? As I said, if you look from the dimension of international conventions, only three types of minorities are taken care of. Ethnic minority, which in fact cuts across religious minority as well as linguistic minority. Predominantly speaking, there are only two types of minorities recognized by the 1992 declaration of UNO. The first one is linguistic minorities and the second one is religious minorities. However, if you ingrain the Constitution of India, you will find that the Constitution of India has taken care of every possible minority that could be found in Indian soil. Minority could be scheduled caste, scheduled tribe minorities. Minority could be even a woman, a child. Minority could be a person belonging to religious denomination. It could be a person who speaks a different language. And therefore, when you focus on the minority rights from the perspective of Indian Constitution, you will find there are many beneficiaries in the bracket of minorities under the Indian Constitution. However, today's talk is not about all the beneficiaries. Today's talk, we will confine only to two categories of beneficiaries. Number one is religious minorities, and the second one is linguistic minorities. Because the essential focus, as I said, of this international convention is on these two types of minorities. If somebody can acknowledge that I'm audible, I can move further.
Yes, sir. Yes, sir. You're audible.
Yes, thank you. See, in India, the central government as well as the government of Maharashtra has recognized 6 religious communities as religious minorities in India. The first one is, of course, the Muslim community. The second one is Christian community. The third one is Sikh community. The fourth one is Baudh. The fifth one is Parsi. And the sixth, which was recently added to the list, is Jain community. These 6 communities, interestingly, are minorities both at the national and at the state level. When I say state level, please always assume that I am speaking about the position of Maharashtra and no other state. These 6 communities are, as of now, religious minorities in India as well as in the state of Maharashtra. Then, as I said, I'll be speaking only about the Maharashtra state because the topic is confined only to the state of Maharashtra as a discussion. You will find here on the screen. Can you see my screen?
Yes, sir.
Yes. See, if you calculate the Indian population, and this is a census of 2011, 74% of the people generally belong to the Hindu community, and therefore they are not minorities at the national level. But please, there is a catch here, and don't forget this. Though Hindu community at a national level are in a majority, there are few states where Hindus could fall, and in fact they are minorities as compared to the state population. Therefore, the screen which is being reflected before you is of the state of Maharashtra as compared to the population of the India. In India, the total minority population is 24%. And in the state of Maharashtra, the total minority population is 29.46%, out of which Muslims constitute 18%, Christians constitute 1.9%, Sikhs are below 1%, Buddhists are 6%, Jains are 2.2%. I'm talking about Maharashtra. And there are other persuasions who cannot be classified as different religions, but they cannot be clubbed with Hindus as well. They constitute 0.17%. And there is an interesting category of population who say we will not declare what our religion is. Probably they don't believe in a religion, or they are not interested in the declaration of their particular religion. This is the status of religious minorities in the urban area. Probably the similar figures with little bit here and there changes go in respect of rural areas also. In rural area, there is 82% who constitute the dominant Hindu community, 87% in the state of Maharashtra, and And the total minority population as far as India is concerned is 17% as far as rural area is concerned. And for the state of Maharashtra, it is 12.94%. As I said, this is a particular data which I have taken from the website of this particular website, and therefore I have provided this link to you. The PPT will be subsequently shared to all of us. You can click and you can verify this particular data. A gentle reminder, this particular census is of 2011. We are not talking about the picture of 2023. As per 2011 census, this is the figure. And if this is the figure, the benefits which are going to be conferred or which are being conferred as of now are based on the population count of 2011. Am I audible?
Yes, sir. Yes, sir.
Yes. Now, what are the rights of religious minorities in India? Because at the outset, when we spoke about that International Convention of 1992, International Convention in fact provides 3-4 rights. It says all religious people shall have a right to express, to profess, and to propagate their religion in the best possible ways. That was right number 1. All religious minorities shall have or should have the right of denomination, forming a group together so that they can collectively exercise their religious rights. And as far as minority rights of linguistic minorities are concerned, the International Convention said linguistic minorities shall have a right of elementary and intermediate education in their own language so that their religion, their script, their culture is preserved. In fact, these are the rights which are also spoken of by the Indian Constitution, probably in a greater detail than what this international convention vouch for. And therefore, we should necessarily look into Article 25 to Article 30 of the Indian Constitution when we are speaking about a right to a religion. At the beginning, I made a presumption that most of the participants here are from the law background, and therefore, I need not go into the essential elements of these articles. I will only make a cursory reference to these articles because you must have studied them, you must have taught them in the classrooms, and there could be n number of discussions on these topic. In India, religion is a typical phenomenon. Why I say so? In majority of the countries worldwide, either the state sponsors the religion or the state distances itself from the religion in such a way that there is a wall of separation, there is a wall of participation. Now, when the Indian Constitution was being framed, these two approaches or these two models were available. Should the state sponsor the religion or should the state remain aloof from the affairs of the religion in such a way that there is no interference in the religious beliefs or religious denominations as such? Striking a balance between these two principles, the Constitution of India speaks for principled distance. Now, what do you mean by this principled distance? This is very interesting. The principled distance of Indian philosophy in respect of religious rights is in the matters of religion, and these words are very, very important because you had, as many of the students here would be of constitutional background, you had 5 case laws to develop the meaning of what do you mean by matters of religion. And after the 1985 judgment of the Supreme Court, we had a little clarity as
Sir, you are not audible.
I'm not audible.
Yes, right, right. Yes, sir.
Yes. So matters of religions are those matters where the state will never interfere. For example, will never interfere into those aspects of religion. However, the state will never remain neutral in respect of secular interests of the religion. To my temple, if this is your belief, if this is your faith, and if you call this as my matter of religion, I am sorry, the state is not going to tolerate this. The state says, secular, not in the interest of the states. The state is not going to keep quiet, and therefore state is going to extremely intervene in the rights of religion. These two aspects combined together is to any of the religions, as long as those beliefs, those observances are the matters of religion. But the moment it goes outside the core of matters of religion, religious rights and the Indianized aspect of rights of religious minorities. Friends, as I said, I will not go into the details, but I will make simply a cursory reference to certain aspects of religions. As you all know, Article 25 rights are individual rights because Article 25 provides those rights to the individual and not to the collectives. Of a particular community, including the corporate freedoms. What these are, let us look into the next slide. As I said, Article 25 of the Indian Constitution in God, you find people who believe in only one or two gods, and there are people who believe in every god they come across. All are welcome under Article 25 of the Indian Constitution. And the second one is right to freely profess, practice, propagate religion. These two rights need a little bit of explanation because substantial explanation is already known to you. You are covered by Article 25. I say there is only one God. Still, I am covered by Article 25. I say every stone, every tree is a God. Still, I am covered by Article 25. Every aspect of belief, non-belief, believer is also covered under Article 25. Non-believer is also covered under Article 25 of the Indian Constitution. And as far as my reading goes, prescribe a particular religion as a straight religion, or else they abstain so much so that they don't interfere into any kind of religions. But Indian Constitution, especially Article 25, which speaks about a right to religion, is such a balanced article which balances individual rights, also provides the rights to the states to intervene in the name of secular and social character. Now, once you believe in a particular religion, you have a right to profess, practice that particular right, and propagate that particular right also. Of course, as I said, subject to the public order, and this is state intervention, by the way, subject to the public order, morality, and other provisions of this constitution. I wish I could have elaborated this slide, in some more minutes, but since there's a paucity of time and I need to attend one more meeting, which is scheduled to start, by 11 o'clock, I shall be rushing my PowerPoints to the next slide. The second right, most important right given to the minority rights is collective rights and corporate freedoms. See, under Article 25, A is a person who believes in a particular religion. A will not be able to fully enjoy the tenets of that particular religion if he is all alone the only believer. Therefore, he needs people who support him. He needs people who can form a denomination. Denomination means a group of people who believe in the same rituals, who are ready to follow the same ceremonies, and who are like-minded. Religious rights, dear friends, as you all know, religious rights can be best enjoyed in a company. Individually, religious rights cannot be enjoyed in that greater fulfillment unless there is somebody there to accompany you, to promote your thinking. And therefore, Article 26 has supplemented Article 25, and it says, as an individual, you have a freedom of conscience, you have a freedom of religion, but since this right cannot be entertained and enjoyed in a meaningful way individually, let us extend this facility of right to religion in a collective manner. And Article 26 says all people of a typical religion or a particular religion or of a particular thinking can form their own denominations, and this denomination will have the character maybe of a trust, maybe of an organization, and this trust or organization shall have these four important rights. What is that? Collective religious organizations shall have a right to establish and maintain charitable, for the charitable purposes, any institutions, including educational institutions. The second right is, am I audible?
Yes, sir. Yes, sir.
The second most important right is, once you establish a particular institution, you shall have a right to manage the affairs of such religious institution. Once you are an organization, you necessarily need, right? You necessarily need a right to own and a right to acquire the property, because all educational institutions, you all know, all minority educational institutions own property, they acquire property, because this is a right which is concomitant to the main right of establishment. And the most important is, all religious minorities shall have a right to administer such property in accordance with the law. Article 25, individual rights. Article 26, collective rights. Coupled together, these two articles cover the substantial aspects of the right to religion, not only of minorities, but of all people. But since the talk is in the context of minority rights, let us say that minority rights can be better enjoyed, minority rights of religion can be better enjoyed in the presence of Article 25 and Article 26 of the Indian Constitution. As we said, no right in the Indian Constitution is absolute, and therefore Article 26 is also subjected to public order, morality, and health. These are the areas where the state can intervene and try to curb the unrestricted freedoms of religious denominations. This is the intervention power of the state. Article 27 and Article 28 are again supplementary to Article 25 of the Indian Constitution. Before independence, in fact, before the arrival of the Britishers, religion and tax, they were a great enemies of each other. You all must have read that during Mughal period, except the Muslims, all people were to pay taxes to travel to certain pilgrimages and to enjoy certain ceremonies. Mughal period went by, the Britishers came. In fact, the Britishers did not, interfere that much in the religious aspects of the people, but the typical tendency they had was they used to promote Christianity in different language, and that Christianity was promoted at the cost of state expenses. In other words, whatever tax was collected, out of that particular tax, certain amount was spent for the promotion of certain beliefs. And this was during the British time. There are many countries world over who tax people in the name of religion. The best example is Pakistan is a state where, tax can be imposed for the promotion of Islam. There is a budget for that. India is a country which says no tax could be imposed on any religion, number one. Number two is, whatever tax has been collected, no portion of the tax could be used for the promotion of any one particular religion. Now, these words are very important. If the government says all religions will be promoted, that's fine. But the taxes collected cannot be used for the promotion of a particular religion. And this, I think, Article 27 is the greatest article which takes away the power of the government as far as interference in religious practices are concerned. Supplement to Article 27 is Article 28, which says, these are the three rights. Let us summarize. If a particular educational institution is receiving the aid from the government, no religious teachings can be taught in that particular school. Second, and second is an, in fact, exception to the first one. Even if a state is receiving the state aid, but the educational institution is founded under a particular trust, which is in fact for the promotion of a particular religion, as an exception, religious instructions can be taught there. And the third most important is, irrespective of whether you are religious minority or someone else, irrespective of whether you are a religious minority or someone else, the state government cannot differentiate in giving the aid even to the unaided, religious minority institutions. You know why this is important? Because religious minority institutions can establish educational institutions of their own, as we saw them in Article 26. But it is not that they could be able to manage those educational institutions out of their own fund. Even such minority educational institutions also require the help of the state aid, and therefore Article 28 supplements Article 26, and it says any religious institution which is a minority religious institution shall not be denied any state aid only because it belongs to a religious minority institution. These three rights, in fact, they require a further detailing, but as I said, for the paucity of time, I'm stopping myself here. Article 25, 26, 27, and 28. These four articles greatly supplement the rights of religious minorities. Am I audible?
Yes, sir. Yes, sir.
Yes. For next, in next 5 to 6 minutes, I'll be finishing off. Let us speak about the second most important minority spoken of by the International Convention as well as the Indian Constitution. And this is linguistic minorities. Friends, as you all know, till 1947, India was governed by provinces, and from 1946 to 1956, there was hardly any agreement as to which part of the state shall belong to which part of the states, because after the independence, states were being organized on the basis of language. Here I can have a best example of Belgaum, which you all know, adjacent to Kolhapur. And we are still in the Supreme Court whether the Belgaum belongs to the Maharashtra, or as it is claimed by the Karnataka, it belongs to the Karnataka. In 1956, states were reorganized on the basis of continuity of culture and on the basis of languages spoken. But, and this cannot be a mathematical precision that you draw a line and you say these people are of this part and these people are of this part. You can't do so. The best example is Belgaum. Many of the people who speak, and in Belgaum, there is a contention that 60% of the people speak Marathi language, and still they are in Karnataka. According to the Reorganization Commission module, if language is to be considered as a parameter to distinguish and define a particular state, Belgaum should be a part of the Maharashtra. That is what we have claimed in the Supreme Court. But as I said, during the 1956 reorganization, many of the areas and many of the territories which should have been a part of one state went to the other state. For example, Marathi people Marathi speaking people went to the Karnataka, and as Karnataka claims, Solapur people who speak fluent Kannada should have been in the state of Maharashtra. Now, once the lines are drawn, you cannot that easily readjust. But the question of their language, the question of their linguistic identities come into fore. And in fact, I tell you, they are the people who suffer the most. And therefore, linguistic minorities were also taken care of by the Indian Constitution by way of 7th Amendment to the Indian Constitution. Who are linguistic minorities? It is a simple formula. If a principal language of a state, for example, in Maharashtra, we speak Marathi. Marathi is our principal language of the state. If there is any group in Maharashtra whose mother tongue is not Marathi, then such persons are considered as linguistic minorities in the state of Maharashtra. In other words, in simple words, the people who do not have their mother tongue as Marathi are to be considered as linguistic minorities in the state of Maharashtra. Now, these people require protection and promotion of their rights as much as religious minorities do. Then, what are the constitutional safeguards provided to the linguistic minorities? Friends, this is for your persuasion. Just a minute. Yes. Maharashtra government has come up with a census in 2011, which has narrated 29 languages as the secondary language spoken of in the state of Maharashtra, and therefore they have been classified as linguistic minorities in the state of Maharashtra. The first one is Hindi, the second one is Urdu, Gujarati, Khandeshi, Telugu, Kannada, Sindhi, so many. Their mother tongue, and therefore these people are conferred with certain constitutional safeguards as well as certain safeguards guaranteed by the mutual understanding of the state. What are the safeguards available to the linguistic minorities? Simple. The Constitution of India provides certain constitutional safeguards. Treatment in the state of Maharashtra, naturally Marathi people will also get good treatment in the state of Karnataka. If Gujarati people get good treatment in the state of Maharashtra, Marathi people will also get good treatment. Two states come together, probably at national level, and by their consensus means by their agreement, is a special national level officer, is a commissioner who takes care of minority rights of the people, linguistic minorities of the people. And states have agreed that best of the best facilities would be made available to the linguistic minorities in every agreements entered into at all India level from time to time in respect of these linguistic minorities. As far as constitutional safeguards are concerned, there are two irrespective of their language. Other than that, certain special and exclusive rights exclusively available to the minorities are made available under the Indian Constitution. Let us see what those rights are. Somebody could help me with my audio.
You are audible. You are audible, sir. Sometimes you are not audible, not audible.
Somebody said I'm not audible. Thank you, Mahesh Sanak. I think I'm audible. Yes.
So please continue. Don't worry for that.
Then Article 14, equality before law, equal protection of law. You all know that. Article 15, which says no discrimination on the basis of religion. You know, these two words are very important. Basis of place of birth. Then Article 19 speaks about six, fundamental freedoms, as you all know. Article 21, which is a constitution in itself. It is the constitution of constitution. Few rights available only to the minorities. The minority could be a religious minority or it could be a language. Conserve the same. What to conserve? If they have a distinct language, script, or culture, such distinct language, script, or culture can be conserved by that particular religious minority, and these rights are extraordinary in the sense that in order to prevail over these rights, the government should necessarily have an eminent interest, a predominant interest. Only then and then can these rights can be stampled upon, which is generally not possible. Similarly, Article 30 of the Indian Constitution says all minorities, whether based on religion or language, shall have a right to establish and administer educational institution of their choice. As I said, all these institutions which are either based on religion or are based on language shall have a right to establish educational institution of their own choice. This Article 30 of the Indian Constitution we spoke about in in the preceding slides, and therefore let us not spend much of our time. Apart from this, there are few more special safeguards available only to the linguistic minorities. And what is that? We have a typical example here. Article 347 says, if special provision relating to language spoken by a section of population of the state, it says if in a particular state if a substantial population speaks of a different language other than the state language, the President of India can dictate the state to make special provisions in respect of that language in that particular state. The best example is, there were many complaints from the Belgaum to the President of India under Article 347 that substantial portion of the population in the state of Karnataka, especially Belgaum district, speaks in Marathi language. Marathi is their basic language, mother tongue language, but Karnataka state is trying to impose their language as the exclusive and the only language, and therefore the state of Karnataka must be instructed to not to interfere into their linguistic rights, plus ensure that Marathi is also a second language, at least in the state of, in the district of Belgaum, where all government notices should come in Marathi language also. And dear friends, based on this Article 347, there were many commissions appointed by the President of India to look into the matters of Marathi, speaking people in the Belgaum district. This is the power of Article 347, which provides special safeguards to the citizens of, linguistic minorities. Supplementing article is Article 350. It says any person can, when he has a grievance, for example, I am a Marathi, I speak Marathi, I'm studied in Marathi, but I don't know English, I don't know Hindi. And I want my grievances to be heard by the President of India, the Parliament of India. The only language I know is Marathi. Article 350 says if there is any grievances, such grievances could be given as a representation in all types of languages, and it is the duty of the state to hear the grievances in the language given by the person who is an aggrieved person. That means language cannot be a bar, language cannot be a barrier in the resolution of the grievances of the people. This is possible by virtue of Article 350 of the Indian Constitution. Article 350A, as I said, came into existence by virtue of that Reorganization Act 1956, by virtue of which states were demarcated on the basis of language spoken. Article 350A says, if in a particular territory, area, take us the example of Maharashtra, if non-Marathi people are living, and if they have a different language than the Marathi, then the state of Maharashtra should make efforts to provide the instruction in the primary stage of education as well as secondary stage of education in their own mother tongue. That means if there are Gujaratis and the population is substantially, strikeable population, then in those areas, if the demand is raised, Gujarati schools are to be established, where of course Marathi would be one of the languages, but the mother tongue is, since Gujarati, the education has to be provided in that particular language itself. This is one more safeguard made available exclusively to the linguistic minorities. Article 350 is very important. Please concentrate. Article 350 says a special officer for linguistic minorities has to be appointed, in fact, has been appointed. And this special officer is not an ordinary person. Please remember, this person is Commissioner for Linguistic Minorities, and he works under the Union Ministry of Minorities Affairs. His job is to investigate in all matters relating to linguistic minorities problem, and he is to report it to the President of India, not to any other person. He is not to report to the Prime Minister. He is not to report to the Chief Minister of the state. He is to report the conditions and the predicaments of linguistic minorities directly to the President of India. And when I was making this presentation, curiously, I was looking into the Belgaum issue. This commissioner has visited Belgaum many a times, only to make sure that the Marathi, people, Marathi speaking people in the Belgaum district do not suffer from unreasonable and unwarranted interference of the states of Karnataka. This is the power of linguistic minority commissioner. And this linguistic minority commissioner, I have given that link to you in this PowerPoint presentation. If you click, you will find out he has extraordinary powers. Powers of, in fact, a civil code to protect and promote the minority rights of the people. Other than the safeguards as made available, up to this, we discussed about the constitutional safeguards. Now, the other safeguard which I presented a couple of minutes ago was, in fact, states have also come together and agreed that mutually we will provide certain facilities to the people who are non-state language people. What those facilities are? These facilities are known as consensual safeguards for the linguistic minorities. What is agreed upon? This is very interesting. If a 15% of the population or speaker in a particular local area speak a different language, then it is expected by the state that all the notices, regulations, and rules are also published in the language the people are comfortable with, or the language they speak in. The best example is, again, people from Belgaum. They constitute more than 15% as a speaker of that language, and therefore they have demanded. In fact, few of their demands were yielded to, but again, it's a matter of state policy. Not everything is provided for, but the consensus is wherever there are speakers who constitute 15% of that local population, and if they speak in a different language, it is expected of the government that all governmental rules, regulations, notices, including light bills, electrical bills, are provided to them in the language they understand. This is a consensual safeguards provided to the linguistic minorities. This is the greatest one. Of all, this is the greatest one. What is that? If of a particular population in a particular region, if 60% of them, more than 50, it is 60% of them, if they speak a different language, then such language shall be considered as second official language of that particular district. Again, the same example. In the state of Karnataka, in the district of Belgaum, it is the contention of Marathi people that in the district of Belgaum, we constitute more than 60%, and therefore, for the state of Belgaum, Marathi shall be declared as the second official language, because the state of Karnataka has agreed, it has consented to at the national level that this facility would be made available to them. Has happened, has not happened, is again a political question. But as far as declarations are concerned, if 60% of the population in a particular territory speak a different language than the language of the state, then such language shall be considered as the second official language of that particular territory. The third one is, mother tongue shall be the language of primary education and secondary education, where there is a substantial linguistic population. Textbooks should be provided to them in their own linguistic language. And the most important is three language formula. Three language formula means, suppose in the state of Maharashtra, Marathi of course would be the primary language. Second is, suppose if Gujaratis are living, Gujarati could be the second language, or Kannada could be a second language, or Konkani could be a second language, whatever. And the third one is, as you all know, national language, which could be Hindi or it could be English. Every state is expected to follow three language formula to safeguard the interest of linguistic minorities. These are the rights which do not find any place in any of these statutes book. They are not part of even the constitution, but they are the part of agreement that the states have entered into in order to protect the rights of each other, right? As I said, you could go to this particular website. It is a website of website maintained by the government of India. There is a commissioner for linguistic minorities in India, and as you click on this particular website, you will find much more details than what I spoke of here, right? So this is all about the national level scenario. When you come to the state level scenario, you find even our state of Maharashtra has a special wing, a special department, अल्पसंख्याक विकास विभाग आहे. ह्या वेबसाईटवरती ज्या क्षणी आपण क्लिक करू, बऱ्यापैकी प्रश्न जे आपल्याला अल्पसंख्याकांच्या बाबतीत आहेत, बऱ्यापैकी प्रश्न सॉल्व्ह होतील. जसे की अल्पसंख्याक कोण असू शकतं, त्यांना संविधानिक तरतुदी त्यांच्यासाठी काय आहेत, जनगणना सांख्यिकीला काय सांगते, त्याच्यानंतर काय उपाययोजना त्यांच्यासाठी केले गेलेले आहेत, जसे की शैक्षणिक उपाययोजना, कौशल्य विकास योजना. ज्या क्षणी तुम्ही ह्या वेबसाईटला व्हिजिट द्याल, almost 90% of your doubts would be cleared in respect of what facilities are being provided by the state of Maharashtra for religious as well as linguistic minorities. So with this, I know I was a bit unreasonable and a bit fast forward in terms of explanation, because as I said, I had a commitment. In fact, my colleagues are hinting me that it is better you shut down. If there are any questions, I would rather take up, and then I would say goodbye to this particular session. Over to Dr. Kolte.
Thank you, sir.
Thank you, sir. Thank you very much for enlightening us with your knowledge and experiences that how minor rights are given to minorities in India under Constitution. Thank you so much, sir. Now, moving further, I will call upon for the presidential address Professor Sri Kishan More, sir, to guide us for the presidential address. Sri Kishan More, sir, over to you, sir.
Thank you. I hope I am audible.
Yes, sir.
Yes.
Thank you. Dr. Praveen Patil, sir, Principal, Shahaji Law College, Kolhapur. Our coordinator of IQSC, Dr. Aparna Kotapalle, madam. My brother, Dr. Sirsat, sir. Coordinator of this NSS activity, Dr. Kolte, sir, and Girbane, madam. All the faculty who have joined this, and the students who are attending this program. I must appreciate your all efforts to celebrate this International Minority Right Day. Sometime it may be called as National Minorities Right Day. And because you have taken effort to celebrate this, I appreciate the efforts taken by Dr. Praveen Patil, sir, for delivering his wonderful lecture on the minority rights. And sir have dealt with the different aspect of the minority right. Particularly, he had taken the reference from the issues of people who are residing in the area like Maharashtra and border of the Maharashtra, and having problem regarding their language. And he had also referred to many provisions of our constitution and different kind of the scheme undertaken by the government of India and the state of Maharashtra. In respect of the minority right, at this juncture, I remember the contribution extended by the Constituent Assembly member, particularly the members of the subcommittee on the minority right, which was uh, constituted for those purposes to implement the condition laid down by cabinet mission. See, we had got the opportunity or permission or liberty to frame our constitution on the condition that to establish the advisory committee and particularly the committee on the minority right to suggest the remedial measures for the protection of the minorities in India. Because of that, we have the provisions due to the contribution of the members of the subcommittee on minority rights. I can only tell one experience, one incident taken place into the debate which were held into the minority sub-right committee. That as there was issue of the partition of India and Pakistan going on, and it was suggested by some members, particularly Mahavir Tyagi, that let us see what response is being given by Pakistan to the minorities, and accordingly we'll have the provisions in our constitution. But that was strongly opposed by Dr. Baba Saheb Ambedkar in the meeting that in that juncture, and accordingly he had taken effort to introduce the provisions in respect of the protection of minorities in our constitution. And due to that reason, we are now able to protect the interests of the minorities under our constitution by law. And accordingly, we have very good coordination in India so far as the minority interests and the efforts taken by the government of India. Only thing is that as a part of the majority people and minority people, see, any democracy cannot neglect the interests of the minority, and it is time for us all the majority to have the compassion toward the interests of the minorities, and let us take the place for that, that we will have the compassion toward the minorities and their all kind of the problems. We'll have a very compassionate approach to resolve those all kinds of problems, because minority in India are having different kind of the problems. Though we have the safeguard under the constitution, though we have different kind of the schemes for the development of them, but despite of all these things, we have many problems, and that one should confess on the day on which we are celebrating the minority right days. I will appeal all the participants to have such kind of the approach to see toward the problem of the minorities, so that it will be a successful effort which we are taking on the occasion of this minority day. So with this, I can assure Dr. Praveen Patil sir, whatever he had guided our student, they will definitely consider those things, and definitely they will implement those things in their action and thought. With this, I am thankful to the organizer for giving me this opportunity to give this concluding remark. Thank you very much.
Thank you, sir. Thank you very much. Now it's time to come towards the end of this program. That is vote of thanks. I am going to give a vote of thanks. Firstly, uh, heartfully, extend my gratitude towards Dr. Praveen Patil sir, that he have given time and very brief in very uh, specific time. You have covered all the aspects in regards with the minority rights. Thank you so much, sir. Uh, as sir is from Kolhapur, so in the accent of Kolhapur, we will say that sir, ज्याक मार्गदर्शन आमच्या पोरासनी केलाय सा. थँक्यू सो मच. आणि तुम्हाला पुन्हा पुन्हा ऐकाया आम्हाला बरं वाटेल. Thank you so much, sir. Then I will thanks to our president, Professor Sri Kishan More sir, for presiding today's program. Then I will thanks to our beloved principal sir, CM Rao sir, who always supports us and gives opportunity to multi-dimensional development of the students. Then I thanks to all the faculty members. Then I also thanks to the principal Dr. Poonam Nathani ma'am, Dayananda Law College, Latur, for being present here. Then I also thanks to Dr. Amit Kashyap sir from Army Law College, Pune. Then I also thanks to Professor Deshmukh sir from Government Forensic College, Mumbai. I thanks to all the uh, man. I thanks to management who always supports us and gives various opportunities to the students. Then I thanks to all the people directly, indirectly make an efforts to make this program successful. I thanks to all the participants and students who are present here. And with this, with the permission of President Sir, I declare that the program is over here. Thank you.